This is Phoebe Taylor,
and Ann Hoover,
and we'll be covering the Yarboro Sallee versus the Tennessee Board of Professional Responsibility suit.
On October 15, 2009, Lori Knoll, a wife and mother of two, fell down the steps in her home in Knox County, Tennessee. She died 5 days later. The medical examiner determined that Miss Knoll's death was accidental. However, Miss Knoll's parents, Francis Rogers and Yarboro Bible, the claimants, were suspicious of her husband, Adam Knoll's role in her death. Rogers and Bible met with attorney Yarboro Sallee after a friend suggested her services to them.
On September 8, 2010, the claimants met with Sallee for the second time. At this meeting, the claimants and Sallee listened to a 911 call in which Mr. Knoll gave an unreasonable explanation for Miss Knoll's fall. Sallee then offered her services to Rogers and Bible. The claimants accepted Sallee's offer and decided to retain her for an initial sum of $5,000. After a few weeks of preliminary investigating and a few more payments adding up to a total of $20,000, Sallee filed a wrongful death suit against Mr. Knoll on October 15, 2010, exactly 1 year after Miss Knoll's fall. The claimants accused Mr. Knoll of killing Miss Knoll in order to obtain her life insurance policy of $1 million.
Sallee then gathered expert witnesses and medical documents, including brain matter slides. She charged Rogers and Bible an excessive amount of money for these discoveries and for her time spent collecting them, never sending the claimants a detailed billing statement. She repeatedly asked for an unreasonable sum of money for her time spent on the case, which included preliminary work such as watching several hours of the 48 Hours Mystery series to study related cases, and doing research online about wound patterns.
After repeated attempts at seeking excessive amounts of money for her services, the claimants and Sallee began to argue about payments that Sallee believed were owed her for her time spent on the case. Sallee claimed that Rogers and Bible owed her in excess of $132,000 for 2,800 hours of work on the case. She sent them a fee agreement which the claimants refused to sign. Sallee threatened to drop Rogers as a client, but the claimants had enough and decided to, quote, drop her instead. In early January of 2011, Rogers and Bible sent Sallee a formal letter releasing her from all legal responsibility in their case, formally terminating her. Sallee was irate about being terminated, accusing the claimants of conspiring behind her back.
After terminating Sallee, the claimants requested their file, which Sallee refused to release to them, claiming that Rogers and Bible still owed her over $80,000.
The claimants responded to Sallee's refusal to give them their file by sending a letter of complaints to the Board of Professional Responsibility. In their complaint, they claimed that Sallee had refused to turn over files, medical records, and other items. Sallee responded with a 21-page, single-spaced letter to the board, and she continued to refuse to turn over their files. Sallee continued refusal to give them their files forced the claimants to hire attorney Larry Vaughn in a civil action suit against Sallee in order to retrieve the files. Vaughn filed a suit against Sallee in the Knox County Chancery Court. This filing in the Chancery Court did not convince Sallee to return the files, and instead she responded by threatening a suit of her own.
The Chancery Court proceedings ended in April of 2011 when the Chancellor demanded that Sallee hand over all remaining files pertaining to Miss Knoll's death.
Meanwhile, the Board of Professional Responsibility began to investigate the claims of professional misconduct made by Rogers and Bible against Sallee.
In December of 2011, the Board of Professional Responsibility sought disciplinary action against Sallee, concluding that she had violated Rule 1.16, subsection D of the Tennessee Rules of Professional Conduct. This rule protects clients' interests after discharging a lawyer.
Sallee disputed the board's findings. In her argument before the board, Sallee claimed that she had handed over all documents that she had not personally paid for to the claimants, such as expert witness testimony. She did admit that she had not returned brain tissue slides for Miss Knoll's autopsy upon request.
The claimants argued that Sallee had sent them a package of only a few sheets of paper that they already had copies of. They went on to claim that Sallee's actions forced them to take materially adverse actions by having to hire and pay Mr. Vaughn to file a civil suit against Sallee. The claimants also argued that Sallee's actions had delayed wrongful death proceedings for 2 to 3 months.
Despite Sallee's arguments before the panel, the Board of Professional Responsibility ultimately decided that Sallee had violated Rule 1.16d, along with several other rules, and suspended Sallee for 1 year and was subject to be reinstated upon proof of rehabilitation. In the panel's decision, they stated that, quote, the respondent violated Rule 1.16, declining and terminating representation, in that respondent failed to promptly surrender papers and property of the client and work product relating to the wrongful death suit, which were necessary to prevent a materially adverse effect on the clients with regard to the ongoing wrongful death suit, and ultimately required Ms. Rogers and Mr. Bible to file separate civil action against the respondent and obtain a court order before the respondent would turn over all appropriate and necessary materials relating to the wrongful death suit to her former clients.
Sallee filed a petition for a higher court's opinion and went to trial in May of 2014. The trial court found sufficient evidence to uphold and affirm the panel's decision that Sallee had violated Rule 1.16d, among other rule violations, by failing to promptly overturn materials. The court noted that she had admitted to withholding certain files until she was demanded to by the Chancery Court. The court upheld the panel's decision to suspend Sallee for 1 year.
Sallee did not accept these findings and motioned for a new trial, which was denied. The one mitigating factor in the trial was that Sallee had no previous disciplinary actions.
Rule 1.16d, according to the Tennessee Rules of Professional Responsibility, states that a lawyer who is discharged must promptly surrender papers and property to which the client is entitled. Sallee broke this rule by refusing to overturn relevant documents and materials upon request from Ms. Rogers and Mr. Bible.
In order to avoid this disciplinary action of suspension, Sallee should not have taken on Roger and Bible's case to begin with. Sallee admitted to the panel that she was counseled to 28 to 30 other cases at the time of the wrongful death complaint. She also stated that she had never previously prosecuted a wrongful death suit. She should not have excessively charged the claimants for her time spent on the case, as she should have known that her relative inexperience with wrongful death suits would necessitate more time spent researching, which is not the claimant's responsibility to pay for.
Another way she could have avoided disciplinary action would have been to promptly give the clients all relevant files upon her termination, which would have enabled Rogers and Bible to seek their wrongful death suit with a new attorney.
And that concludes the case of Yarboro Sallee versus the Tennessee Board of Professional Responsibility. Our sources include Westlaw and the Tennessee Board of Professional Responsibility Rules of Professional Conduct.